Hey y'all, I'm Mayer Cunningham, the special education boss. If you've ever felt confused, overwhelmed, or just plain frustrated at the 504 IEP table, you are in the right place. Every week, I'm breaking down the rules, the rights, and the realities of special education so you can walk into meetings informed, empowered, and ready to make real change. And whether you're a parent, a teacher, an advocate, a school-based member, or somebody who's just trying to do right by a student, this podcast gives you straight talk, real answers, and tools that you can use immediately. I'm not here to play politics. I'm not here to play sides. I'm here to train people who sit at the table and teach you how to follow the law, ask the right questions, and protect the rights of students. So go ahead and hit subscribe, share this with a friend, and you know what? Meet me back here every single week. We're not just talking about change. We're making it. Because when you know better, you do better. And when we get it right for the child, we get it right for everybody. Hey guys, we are in a series of Parents Procedural Rights. If we haven't met, I'm Mayer Cunningham, special education boss, helping families navigate and negotiate the 504 IEP table and individuals that sit there. So welcome. We are in week 1. The Notice of Procedural Safeguards in Texas is 2021. When you're doing IEP 504 meetings, make sure that the copy that you're providing or receiving from your state is current. They update them at very random times. If they give you one that's not current, then your procedural safeguards have been violated, and that's a denial of a free, appropriate public education. And so you guys can pull that later if you're watching that later. Yes, Flanagan, we love the Flanagans. You need to make sure that you have read yours. Every state has a copy of these. They have two things, right? You have the procedural safeguards and then the guide to the IEP process or the guide to the ARD process if you live in another country called Texas, right? So I'm just going to read you a little bit out of it, and then we're going to kind of unpack specific ones. We're going to do these in shorter blocks in this series so that we can exhaust any questions you have around each of them. For those of us that train, we do it so often, we just say it so much. We're like, he was denied FAPE, and then IEP timbership, and then predetermination, and da. People like, what is she talking about? Okay, so I just want to really unpack it so everybody knows. For the procedural safeguards in special education under IDA, the term parent means a biological parent, an adoptive parent, a foster parent who meets state requirements, a guardian, an individual acting in the place of a parent, or other relative with whom the child lives, an individual who's legally responsible for the child's welfare, or surrogate parent. So I want to park there for just a second. There are often many parents involved in an IEP meeting. Not all parents stay married if they were married. So it's very important wherever you see at the IEP table, or you're going to, especially if you're going to be an advocate for a profession, if the school says, oh, well, Kelly comes by herself, her ex-husband, Bobby Joe, never comes, we've never seen him, her daughter's a senior, we have 1 month of school, I don't care. You as an advocate or somebody that sits at the table, whether it's 504 IEP, make sure that you have invited that other parent. They live in the Philippines. Great, they have email in the Philippines. That you invite them, right? You are legally responsible for doing that. If you sit at the IEP table, you're legally responsible for giving that information if you are the parent. So just for this training, I got divorced to help you out with this process. So when you get divorced, not this week, as well. When you get divorced, there's a little section that says who has educational rights. And it may not look like the custody, right? A lot of people have split 50-50 custody, but one parent has sole educational rights, or one parent has primary educational rights, which means if her or whoever doesn't have primary, if they disagree, that person's vote is it. Does that make sense? If you have equal educational rights, both parents have to agree on an education need, whether it's we've decided to go to private school, we've decided whatever, right? So it's really important, we fly right past that, especially in little town USA. We all get to know each other, and you're like, oh yeah, it's Brooke, it's fine, da da da. Her husband said it was okay. You want to make sure that's clean and open record. So you invite them, or at least you have an email trail where Brooke's like, hey, Aubrey, what's your ex-husband's name? Aubrey's like, there's been so many, I can't remember, right? So at least she has that email trail of, as the case manager, she was attempting to locate that person, especially since the world is so connected by an Ethernet cord. A hearing officer or somebody that's going to look at your case is not going to say that you made a good attempt at reaching those persons. There are parents that are never involved, and they show up one day in 9th grade. Who are you? And they want to be involved at that point, and they have that legal right. So make sure that that's being delivered to them. So the school is required in your native language. Let's just park there for a second. The school is required in your native language to provide you a copy of the procedural safeguards. So I have clients who are obviously speak another language and are often asked if they need an interpreter, but I've never seen anybody offer them procedural safeguards in Spanish. I've never seen them offer procedural safeguards in Vietnamese. I've never seen them offer procedural safeguards in Mandarin, although they're all available on the state website. So if that is not your primary language, make sure that your primary language, that you get your procedural safeguards in that language. The school is required to give you the notice of procedural safeguards only one time a school year, except the school must give you another copy if Karen comes. No, it doesn't say it. The school must give you another copy upon initial referral, your request for evaluation, your receipt of the first special education complaint, first due process complaint, a decision to make a disciplinary action, change of placement, or, which is not in here, a disagree IEP meeting. If you disagree with the parent, disagrees with you, whoever you are, if you're the school-based member, make sure, even though at the beginning of the meeting, she said, yes, Brooke, I have my procedural safeguards. At the end of the meeting, we disagree. Great. I'm going to provide you another copy of your procedural safeguards. Even if she says she doesn't want them, you hit send, right? You hit that with the non-consensus because that is a requirement. Because each time you get to those places, then that triggers where a parent might have to invoke her legal rights, which are outlined in the procedural safeguards, right? That's where the parent may invoke her procedural rights, which are outlined legally in her legal rights in the procedural safeguard. Does that make sense? Right? So it's your job to make sure that she has them. So unlike class notes on the internet, like she can just get her notes off the internet, off the cloud, right? You have to provide them a copy. So one of the most important things that school-based members must do is Brooke needs to make sure, Heidi, you need to sign 2 things you got to sign, right? You have to sign for your procedural safeguards and you have to sign the invitation. So make sure that you are doing that if you sit as a school-based member. Okay. So foster parent, as a parent, there's much language of that. A lot of the software now, Success Ed has it. I think the software that Houston ISD uses it, but now there's sort of an opening line after we sit down at the table and they say, are y'all going to act right? If anybody attacks the school-based members, it's over. I love it. What is it? The meeting norms. No biting teachers during the meeting. Do you all agree to them? You know what I do? I'm not even a member of the committee. How can I can't commit that I'm not going to bite anybody, right? So after that, I've now had much language in meetings where they'll say, does the student, it's actually a question, does the student need a surrogate parent? And I'm sure a lot of you that sit in schools, you probably heard it, Brooke, you've heard it. And we have to say no, because the parents are sitting right here, right? So if a child needs a surrogate parent, the educational agency, the LEA, the SEA, the state education agency, the local education agency has an onus to make sure that child with an identified disability or soon to be identified disability, if you're sitting in an initial, does have a parent. And so we've talked about this at length. We'll continue talking about it. If you're on the planet and you're in between the ages of 3 and 22, and you are in special education, whether you're in juvenile, whether you are homebound, whether you are or been removed from the district for getting in a fight, for a disciplinary action, whether you're in a psychiatric unit, whether you're in ICU at Texas Children's, the school district has to come to you and provide you your IEP. Period. There has never and still is never an exception for delivering anything other than the total IEP. But all of you guys that went out and signed those contingency plans, the federal government doesn't recognize them. You just go file on them. I'm not telling you to. So even if you signed and accepted a contingency plan, which we all know is bologna sauce, right? General ed kids didn't have a. Would you like to reduce your educational product like that? Would you like to get less of what you were getting if we go remote? During COVID, we were so on it. Betsy DeVos never gave us an exemption for COVID. Never, nothing. There's no exemption. So those of you that went out and presented to all your families the contingency plan, right? If there's a shutdown, you get 5 seconds of OT, just like in a video, and you get 5 minutes of this. You agree to that, right? Right? Did you want to sign here? Okay. So if I'm in a meeting, I always say, while we recognize that the district has developed a contingency plan, this parent at this time does not accept the contingency plan. Should the district shut down, the doors are locked, we can't get in for any reason, we are amenable to a brief IEP meeting to discuss another educational platform. No, I don't agree to call Julianne. I love how it's always a case manager. And they put Julianne's name on there. Julianne's a case manager. If we shut down, you just call her. I was like, Julianne, we're just gonna show up in your front yard. You're just gonna bust out like a book from the little red. I'm like, why are we calling Julianne? She can't get in the building either. I thought that was great. So your first procedural right is child find. And I feel like it's the same story we tell every time. Even this morning, like they just lied. It wasn't even so I can have testing and language and psychological, but I can't have assistive technology unless some LSSP says I can. We just make up like every day. Like every day, make it up as you go. And she's been a diagnostician for a very long time. And up until 8:07 this morning, I had great respect for her. I was scared of her, but I had great respect for her because she's a very good diagnostician. But she's just lying, right? I mean, if all the things I've ever heard, have any of you heard once the school finally grants it, like they're giving you like Chick-fil-A, like not Chick-fil-A sauce, because they give you that, that they're giving you sweet and sour sauce at McDonald's and not charging you a quarter, right? And she was like, Miss Cunningham, if the LSSP gets in there and finds something, what is this, exploratory surgery? I said, that's not how this works. I said, it's not how it works. So the illegal things that happen around child find are rampant, and they are from coast to coast and including the other country, Alaska. So we're here to clean all of that up. I just can't believe what happens to families when I sit in a meeting and then when you sit in a meeting without that information. So we want to make sure that we're doing it right. So child find is the basis and foundation. It is special ed. You should be able to recite child find forward and backwards. And as many of you had the blessing of sitting and watching our amazing due process hearings, nobody at the school knows. I mean, you could say child find was spelled with a K. They don't have any. Does ch have a K sound? I don't know, but you know what I mean. They don't know. They don't know where it is. They really don't. So child find, it says all children with disabilities residing in a state who are in need of special education and related services. Oh, and really, wow, I wonder when they typed that in. Including children who are homeless or who are wards of the state, and children with disabilities attending private school, regardless of the severity of their disability, must be three things. What are the three things, kids? ILE, identified, located, and evaluated. Wait, there's no sort of, that's so weird. So have you guys ever seen anybody in your neighborhood out there going, anybody having trouble reading? Anybody like walking down the street, just knocking on doors, reading? Anybody? I've never seen that either. So as part of its child find activities, I love it. As part of its child find activities, the LEA must publish or announce a notice in a newspaper or other media or both with circulation adequate to notify parents in that district or county of the activity to locate, identify, and evaluate any special education and related services. So let's just park there. You guys are on the planet, right? Raise your hand if you're not on the planet. Okay. How many of you guys, and I'm old, so we didn't have, newspaper wasn't invented when I went to school. How many of you guys have ever seen that circulated in your newspaper? How many of you guys have ever seen it come home in the Tuesday folder where we stand over the trash can and we leave it? How many of you guys have ever seen it on a poster in a school district? So I've heard that teachers have it in the teacher's lounge. Maybe they're still outside. They haven't brought them in. Procedural safeguards are your federal rights. So in case you don't know it, OSEP, the Office of Special Education Programs, the federal office, has a very robust letter that says, let me be clear, RTI or any other fancy schmancy stuff that you're doing is no exception for going straight to referral and testing. There is no, and I know all of you lovely, wonderful people that work in schools are required to do something else before they evaluate. I know, it's not your fault. It's the people at the top that are busy having lunch at Perry's Steakhouse. But we're going to fix that because we're all disruptors. So I would ask at your meeting, if you don't know, can you please, respectfully, can you explain child find to me? So when I tell you schools don't know what you're talking about, I mean the special ed director, the executive special education director. There are no requirements to be the special education director. So I just want you to know, you already know, whoever you are, more than anybody in the building. So child find, that is the base of everything good and right. So child find says that the LEA, the local education, has a duty and a responsibility. Write that down. They have a duty and a responsibility. You have duties and responsibilities. Do you have options when you're a nurse or a police officer? No. You have duties and responsibilities. Why? Because you take federal funds, just like those other entities. Here's the short version of child find. The local education is charged with going out, identifying, locating, and evaluating. ILE. In your meetings, I expect progress, or I'm going to call that lady, or I am that lady. Okay. So ILE, just make that your new thing. ILE. It's their job to identify, locate, and evaluate. Didn't say anything about Jahida showing up saying, please. Has nothing to do with parents. That is a lie sold to you for years. Has nothing to do with parents. The responsibility sits solely on the school district. The school district has a responsibility to go out and identify, locate, and evaluate children with, let's say it together, confirmed disabilities. No, children that take medicine. Children that have parents with natural hair color. No. Children with suspected disabilities. So if it's suspected, there's no onus to prove it, right? We're not in court. There's no burden. And so it's suspected disabilities. ILE, the school has to identify, locate, and evaluate children with suspected disabilities. And so what are those areas that we suspect disabilities in? Academic, functional, behavioral, emotional, communicative, and all sorts of other things. Okay. Even this morning in that great meeting that was a whip, 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 she said, and then when your child has mastered all of her academic goals, she will no longer be in special ed. Really? She has ODD, ADD, ED, and she's self-injurious. I don't think we were talking about math. And she's the diagnostician. Do we get out of special ed when there's no more academic need? No. When there's no more what? Educational need. So we have got to get off the academic train, right? So termination of special education. So we do want to talk about this. So special education is consensual. Forget general ed. Special education is consensual. We have one of our friends in the academy and went through an amazing due process, and we thought we were in love now. And now the school is saying that we can't leave the bad general ed dyslexia. We have to stay. What? No. Special education is consensual. If they say to Jahida, your daughter meets eligibility for speech and Braille and adaptive PE, and you don't want it, you don't give consent for those services to begin, even if we've identified them. So special education, whether it's the special education and or related instructional services, are all consensual, right? So you need to know that. So in general, the procedural safeguard notice. So the basis foundation of parental rights under the IDA is referred to in both the statute and regulations as procedural safeguards. The regulations at 34 CFR 300-504C identify a list of 13 such safeguards, which are discussed in detail below. An additional IDA parent right is encompassed by the district's obligation to provide notice of these 13 procedural safeguards. So at your next meeting, ask Ms. Cindy, the IEP facilitator, could you go over in detail my 13 procedural safeguards? I mean, and then just get like a salty snack, because you're going to be there for a minute. She doesn't know what you're talking about. So we want you guys to know what they are. Okay. So number one is that notification requirements. And this is the only thing that we're going to unpack tonight, because it is a big deal. And we're going to do a deep dive training on the PWN, because if you really know how to use it, it's a very effective mechanism of procedural violation. So notification requirements. The district must notify parents with a copy of the procedural safeguards available to them under the IDA. Such a copy must be furnished only one time of the school year, except that a copy must also be given to parents upon initial referral, not the testing, but initial referral, upon receipt of the first state complaint, upon the receipt of, it says the first due process complaint, in accordance with disciplinary procedures, where removal of a student constitutes a change of placement. If you remove a student with a disciplinary action that has a disability, that constitutes a change of placement, and upon parental request. Okay, so those are the four things, right? Upon initial referral, parental request, upon receipt of the first state complaint, and these are the same line, or due process complaint, in accordance with discipline procedures, where removal constitutes a change of placement. Removal from the campus, even if it's disciplinary, constitutes a change of placement. And then, of course, under parental request, we kind of unpack that a little bit more with more specificity. If you are in a disagree ARD, as it relates to Texas code, it might not be in other states, but there's an additional responsibility in Texas. If you are in a disagree IEP meeting, again, you have to offer them another procedural safeguards, right? So that they know their legal rights. Could they reconvene? Could they be offered a reconvene and decline? Could they be not offered a reconvene even though you asked for one? Okay. Next, the district may place a current copy of its procedural safeguards notice on its website if it has one. So you guys, I want you to go look on your district's website and see if you can find one, see if it's current, and see if it's accessible. The required contents of the notice are detailed in 300 CFR 300.504C. That regulation mandates that full explanation of the following topics, and they are an IEE, an independent educational evaluation. That is something that you can request when you are denied initial testing. Write that down. People don't know that. If you're denied initial testing, then you request an IEE. People don't know, they said no. Great, then we'll request an IEE, right? So at that point, Cindy Luhu, the special education director, will have to respond and say, Ms. Smith, we got your request for an IEE and we are not granting that. If you ask for an IEE and the school district will not grant it, what must happen? The school district is obligated to take you to due process, which that'd be fantastic. That could be a witness, right? So who's going to take you to due process over granting an evaluation? I've never seen that happen. But most people don't trigger that. They just go away and get their own evaluation. You can ask for one when you're denied initial testing. You can request an independent educational evaluation when you disagree with a component or components of an initial evaluation, or you can disagree with the totality of an initial evaluation. You can ask for an IE when you disagree with any other evaluations after the initial. So one of my favorite phrases is, which actually does happen, I agree with your evaluation, I just don't agree with your summary and conclusions, especially as it relates to the LSSP. An LSSP might say that's ED, and I say that's AU. And another LSSP might say that it's ADHD, right? Because those circles kind of overlap. And so we don't say, you're a liar and an idiot, what are you thinking? We don't say that because we're all grown. So you would say, I disagree with that section of the evaluation, or I just disagree with your summary and your conclusion, right? So a lot of you have been told, well, you have to agree with the whole thing, or we can't start services. Or if you disagree, she can't have anything. That's not true. So I can disagree with any component of evaluation. I can disagree with any component of the IEP document. So if I say, I disagree with Palmer not having, pod time, it doesn't mean he doesn't get an IEP. And then we get that all the time. I mean, we want you to sign. I know you do. And I do want to sign, but I want to sign when it's what? When it's right. Excuse me. So know those rights as it relates to them. I am not the advocate, and I hope when you become an advocate, you're not the advocate that just wants an IEE for everything. There are some advocates, that's all they do. We disagree. You found him eligible for everything. Yes, we disagree. With what? We can't tell you. That is terrible business. That's terrible manners. We have enough shenanigans in advocating. Don't be that advocate. If you disagree, well, you don't have to tell them the totality of what you disagree with. That's what I say. I disagree with your conclusion, and I disagree with parts of your section, and that's plenty. Additionally, you don't have to be interrogated. We have to know why you want the outside evaluation. Well, I'm happy to give that information to whoever's going to either grant it or deny it. And I just go right back to that. If you're going to deny Ms. Simpson from having an IE, please provide that denial. That's the word we use, denial. You're either granted or denied. Please provide that denial by close of business today. Well, we didn't say we we're going to deny it. I said, well, it kind of felt like it. But you know what, our feelings belong, not in a meeting, right? So it's just a business. You're very clean. If you're going to deny that, please put that in a prior written notice by close of business. We didn't say that. We certainly wouldn't type that. Super. So when can mom come and sign notice of consent? Right, you just move it right into that. So when can mom come and sign notice and consent? Now, the next thing that you're required to have notification to the parents is prior written notice. And we'll unpack all of these. Prior written notice is rarely done well. Rarely done well. Sometimes you sit in a meeting, which I don't like, it's very sloppy. Agreement constitutes prior written notice. What? A reading of these deliberations constitutes prior written notice. I heard it today and I was just like, I don't know where that came from. Prior written notice is prior written notice. Agreement doesn't constitute prior written notice, even if you agree. So you want to make sure that not only do you get your final copy of your IEP, right, or your final signed evaluation, you want to make sure that you get a copy of your prior written notice. Should you go into dispute, those components of what you disagreed on should be captured there. As many of us know, the prior written notice really sounds like the school is awesome and the mom is scary, right? I don't know why she's so upset. I don't know why she was jumping on the table because you were on the other side, right? You can also disagree with the prior written notice. You don't get what you get and you can't throw a fit, right? And so we've talked about that before, that you obviously write, if you haven't captured it at length in the deliberations prior, that you provide them with your written disagreement, right? And then the notification requirements, that you have access. The regulation mandates a full explanation of the following topics. A full explanation of the following topics: an IEE, a prior written notice, parental consent, access to records. They will go to great lengths to not provide you access to educational records. There are protocols that say that you can't make a copy of it. If it's in the assessor's kit, it's actually part of the protocol booklet. However, if they're saying, Palmer wrote on this, I can't let you have a copy of it. It's a post-it note. It's not part of the protocol, right? So if you can't photocopy it, you just go there with your eyes and you Xerox it with your eyes. I know you guys have that chip in your eye, right? So it's really important that you have access to educational records. Next, you have to have the regulation mandates a full explanation of the opportunity to the parents, that you give them an opportunity to present and resolve complaints through due process, take complaints, including the time period in which to file a complaint, the opportunity for the agency to resolve the complaint, the difference between the due process and state complaint procedures, including the jurisdiction of each procedure, what issues may arise, filing and decisional timelines, and relevant procedures. Who's ever given you a full explanation of that? Yeah. I mean, all the time. You have any what? It didn't say they would answer questions. They're mandated to give you a full explanation. So I'm reading you these things because these are things that you could file that you were denied. I was denied a full explanation because you guys are going to go out there and be amazing, pristine state written complaint writers, amazing federal complaint writers, amazing due process writers. So all of these things are requirements and they're mandates. Never happened to me. Never happened to one of my meetings. Never. Okay. They're required to explain the availability of mediation. Now, I have had a diagnostician a couple weeks ago. It was actually, it was a reeval, and the mom's an attorney, the dad's an attorney. They thought they could go without me. And she goes, I said, you didn't sign, did you? She goes, yeah, I just wanted to get over with. Okay. I said, well, she goes, I said, what happened? It's funny how quickly attorneys fold. She goes, well, she said if I didn't agree that we had to go to mediation. what? So I emailed back in my gentle German Irish way. And I said, I'm concerned that mom was told, just because she wanted to come back with, now she has representation, that you told her if she disagreed, she had to go straight to mediation. The diagnostician called me. Miss Cunningham, did you have some questions? Isn't that funny? I actually don't have questions. I'm giving you the questions, right? And she never answered it. So I called the coordinator. I said, you that's kind of weird that you would just say, we disagree if you go to mediation. Like, what is that? So not accurate. We call it not accurate. What's the word I'm looking for? A lie. Yeah. A full explanation of the child's placement during pendency of any due process complaint. Any of you gotten a full explanation? Any of you guys ever been told the word pendency? No. Okay. Full explanation of procedures for students who are subject to placement in interim and alternative educational setting. A full explanation of requirements for unilateral placement of children in private or public schools. You probably got that explanation, right? A full explanation on hearings and due process complaints, including requirements for disclosure of evaluation results and recommendations. A full explanation of state level appeals. We got that. A full explanation of civil actions, including the time period in which to file. We get that all the time. And a full explanation of attorney's fees. Yeah, we got that too. So that is just a starting place. That's why you need to invest in these sorts of publications. They're not the only one that does school districts, but this is what they're teaching to school districts to avoid. And the protections are in place for you. They have a right to do, a responsibility to do these things, and they have a responsibility to inform you of all of this information. Have any of you ever been informed really on any section of the procedural rights as you sit at the table? I've only sat in 10,000s. I've never seen anybody stop and explain it. I have seen them do this. Have you guys seen them do this? Okay, in the back page, on the very back page, I'm right here. These are your dispute options: a facilitated meeting, a state complaint, mediation, or due process. There are the emails. They go right to the back page if you want to file. Oh, okay. But most of you in your state, you didn't even get that, right? So here's the thing, they're not your rights, A, if you don't invoke them, and B, if you don't know what they are, right? I have lots of legal rights that I don't know. I'm not an attorney, I'm not a judge, but the judge of this county or the constable has no responsibility to come and, would you like to know your rights? I would. I feel like I've heard that phrase before. It was during the 80s. But a local education agency has the responsibility to explain those sections. So I think it's important, as most of you are going to go forward and advocate for a loved one or be professional advocates, that even if you know that you say, hey, Brooke's my client, and she had some questions around the right to have informed consent. Can you explain that to her? Well, I mean, we're gonna have another lady send the papers home in the backpack. I didn't know the backpack could inform you. It does. I mean, you just take it out and you sign it. Okay. So when we talk about it in our trainings, and we talk about it this week, and I talk about it all the time everywhere, I am prepared for war. I expect consensus, right? I didn't expect that this morning. Like, I just got up. Are we really doing this? Just right out of the gate. And I've known this diagnostician for 15 years. Like, oh, you work at a charter school, right? So you have to be ready to protect your procedural rights, the one person that you advocate for your clients that are receiving or possibly receiving services under IDA. And for all of you lovely school-based members who we love, we know that nobody ever told you any of that. So I would recommend that you read this. It's great information. And that you ask the parent at the meeting. I'm not asking you to do all that, but I'm asking you to say, hey, Ms. Velez, do you have any questions about your procedural safeguards that I'm providing you? Almost always they're going to say no, but, and there's also for ours and most DOEs, there's the Department of Education, there's a state number or email that you could ask questions about. But for all of you that are school-based members, you're going to say, do you have questions on, did you receive them? Did you receive them? Did you receive them? Yeah. Because most parents are going to go, oh, I got to, you want another copy of this? What do parents say? Oh, I can wallpaper my bathroom, because they think it's the same version that Caitlin has, 2016. They change all the time because they change when there's some adjustment, and obviously out as soon as the legislative session is over, they're going to be updated. Sometimes they're just updated, and I can't even find the update. It just has a new date. I've never seen anybody explain it, but that's your responsibility if you're a school-based member, and that's certainly your responsibility to be given. The procedural right is the protection of the parent, right? Why? Because we can assume they don't know federal special education law. That's an assumption, right? I have them at home. Okay, so then we will see you guys in the next training.
Hit subscribe, share this with a friend, and you know what? Meet me back here every single week. We're not just talking about change, we're making it. Because when you know better, you do better. And when we get it right for the child, we get it right for everybody.